Hello, everyone. A happy prior Christmas, just 2 days away, December 23rd, 2023, 7:37 p.m. The purpose of this video is because I want to make everyone throughout the whole country and also around the world know about South Carolina not wanting to acknowledge its own constitution. Now, as most, if not all of you know, or else I hope you know, the fact that our United States Constitution is the supreme law of the whole country. And the Congress of the United States, any federal laws they make have to line up with the United States Constitution. Now, each state in the Union, from the state of Maine down to Florida, out to California, up to Washington, Alaska, and Hawaii, and also U.S. territories such as Puerto Rico. Each state happens to have its own constitution that is supreme law inside that state. But yet that state's constitution has to abide underneath the United States Constitution, which is to say that each state's constitution is the supreme law in that state, just underneath the United States Constitution. And of course, the state's constitution, the state legislatures or also the state lawmakers in that particular state, any statutory laws they make have to line up with that state's constitution. They cannot conflict or else contradict. Now, if I could please, I named South Carolina because South Carolina will not acknowledge its own constitution. If I could please, and I'm hoping that the video will come in better, had this phone turned sideways, and I'm trying to make this be seen just right. It says, this is Article 1, Section 23 of the South Carolina Constitution. It says, and I quote, the Constitution of the, it says, the provisions of the Constitution shall be taken, deemed, and construed to be mandatory and prohibitory and not merely directory, except where expressly made directory or permissory by its own terms. Now, what that basically is saying, ladies and gentlemen, is this. That's saying that the Constitution in South Carolina is the supreme law in South Carolina. Now, back in 2010, at the Greenville Technical College Strom Thurmond Criminal Justice Building, this law professor, I had called and spoken with her and asked her as to how that the General Assembly of South Carolina could make statutory laws, to contradict the South Carolina Constitution. And this woman law professor had the nerve to tell me, she said, and I quote, she said, "Sir, they can make laws to circumvent the Constitution." Those were her words. Circumvent means to go around, just like usurp. When you talk about usurpation, which means to undermine. And I totally disagree with that. Now, this here, just to let you know, this here is another part of the South Carolina Constitution. I just showed you and even quoted to you as to what Article 1, Section 23 of the South Carolina Constitution says. In fact, if you look right here, you'll see where it says South Carolina Constitution. It's Article 3 right there, South Carolina Constitution. Section 33, what's called the age of consent. And I'm trying to hold this clear just so that everyone can see this. It says, and I quote, "No unmarried woman shall legally consent to sexual intercourse who shall not have attained the age of 14 years. That constitutional amendment came out back in 1895. And that's what it says. You will not find this on the internet. If you try looking it up, Article 3, Section 33, South Carolina Constitution, it will say removed for revision. That's what it will actually say, removed for revision. You'll have to get the old hardback book. You'll have to contact Westlaw Digest, Volume 21, Code of Laws of South Carolina, Volume 21, Constitutions. And of course, in the book, you should be able to find Article 3, Section 33. Now, as I said, that constitutional amendment came out back in 1895, way before I was even born. I'm going to be 60 years old next month. Now, in 1962, the General Assembly of South Carolina made this statutory law. And this statutory law conflicts and contradicts the South Carolina Constitution, Article 3, Section 33. In fact, a lot of men have been wrongfully convicted for something that the Constitution says is legal. Do I think it's right and okay? No, I don't. But I'm just saying it's what the law says, because the Constitution is the law. I want to show you this right here now, if I could, please. This is copied from Title 16, Crimes and Offenses, Volume 7A. This is South Carolina Code Annex Section 163655. It is paragraph 2. For the record, in the new books, it will say Section 16-3-655, subsection B, paragraph 2. It reads, and I'm trying to get this as clear as possible. I apologize if it's blurry. Please forgive me. But it says, and I quote, "A person is guilty of criminal sexual conduct in the second degree if the actor engages in sexual battery with a victim who is 14 years of age or less, but who is at least 11 years of age," unquote. Now, ladies and gentlemen, the reason why I wanted to bring this to your attention is the fact that a lot of men have been wrongfully convicted for what the Constitution says is legal. As I said, now, do I think it's right? No. But yet, what I think, or it's like other people think, doesn't matter. It is what the law says. The Constitution is the law. Without the Constitution, there is no law whatsoever. Now, that being said, let me state this here now for the record. Former Attorney General for South Carolina, who is now Governor, Henry Dargan McMaster, he had this rule in his office for like all of his subordinates. That rule said this: no matter what, appeal everything. And subordinates, assistant attorney generals in South Carolina, they will manipulate. Whenever an inmate tries to do a post-conviction relief application, the assistant attorney general will do their best to either scare the inmate into like withdrawing from their post-conviction relief application, or else the judge showing favoritism towards the state, to which that would be impropriety in doing so. And so therefore, that judge is wrong to dismiss a said post-conviction relief application. I made this video, ladies and gentlemen, in hope and prayer that, like, if you yourself, or you have a family member, a friend, or someone you know who has done time down the road and who has to register as a sex offender, if they were convicted for what's called criminal sexual conduct second degree, they were wrongfully convicted. And I'd been promising I would blast the state of South Carolina for this. And people who were charged and convicted. Now, repeat offenders, no. This should not apply to them at all. They should be put under the jail. But yet those who, like, shall we say, first time, who didn't know the law, they should be granted leeway. Because it's the Constitution, not the statute. It's the Constitution that's supposed to be law. And so therefore, I'm asking you here now to pass this video along to everyone you know of. Let it be known that South Carolina will not acknowledge its own Constitution. Thank you.